Welcome to The Explainer. Today, we're diving straight into a totally high-stakes 1906 Supreme Court antitrust case that literally permanently defined how the government investigates powerful corporations. You know, if you've ever wondered exactly where the government gets the authority to just demand thousands of internal documents from a massive company during a monopoly or fraud investigation, well, it all traces back to this exact moment in legal history, Hale v. Henkel.
Here's our roadmap for today. We'll be looking at 6 key areas that really acted as the foundational battlegrounds for this case. First, the corporate subpoena. Second, grand jury powers. Third, pleading the Fifth. Fourth, individuals versus corporations. Fifth, Fourth Amendment limits. And finally, modern oversight. Let's just jump right in.
Section 1, the controversial corporate subpoena. Okay, so we start with the inciting incident. The year is 1905, and a federal grand jury is investigating potential violations of the Sherman Antitrust Act by 2 huge players, the American Tobacco Company and the McAdrews and Forbes Company. Enter our central figure. His name is Edwin Hale, and he's a corporate secretary and treasurer. Hale just outright refused to hand over his company's secrets to the government during this monopoly investigation, and that defiance set the stage for a massive legal showdown.
Now, the specific legal instrument the government used against Hale is known as a subpoena ducis tecum. That's essentially a Latin legal phrase that means in order to bring documents or evidence with you to court. As the Supreme Court noted at the time, without this very specific power to compel the production of documentary evidence, prosecuting illegal combinations and actually carrying on the administration of justice would be pretty much utterly impossible.
But to really get why Hale refused, you have to look at what the government was actually asking for here. I mean, imagine you're an executive and you are handed this list. The grand jury demanded all understandings, all agreements, correspondence, telegrams, and reports between his company and over a dozen other companies located across 7 different states, going all the way back to the company's inception. Hale basically argued it was a physical impossibility to gather all of this within the time allowed, and beyond that, he claimed he was under absolutely no legal obligation to comply.
Actually, before even getting to the documents themselves, Hale tried to stop the whole investigation right in its tracks. He basically argued that the grand jury had no right to question him in the first place because, well, there was no specific, formal charge pending against any particular person. He wanted to know exactly what the charge was before he breathed a word, and that leads us directly to our first major legal question.
Section 2. Grand jury inquisitorial powers. Let's look at how Hale's argument forced the Supreme Court to issue a definitive ruling on the true, sweeping power of a grand jury. To figure this out, the Supreme Court actually looked backward to understand the present. They traced the evolution of the grand jury, starting from the ancient English system, where a grand jury could just act on its own volition to inquire into crimes, all the way through early American courts, right up to modern U.S. practice. And this historical deep dive brilliantly illustrates that a grand jury doesn't need to wait around for a formal charge to be written up by a prosecutor. Their very purpose is inquisitorial. They are literally meant to investigate and determine if a crime even occurred in the first place.
So the crucial takeaway here is that the government is fully empowered to summon you to testify just to find out who should be indicted. The court affirmed that grand juries possess plenary inquisitorial powers. They don't have to tell you the specific nature of the charge, they only need to let you know the names of the parties involved. And with that ruling, Hale's first defense that there had to be a formal charge first was just completely dismantled.
Section 3. Pleading the Fifth Amendment. Having lost his grand jury argument, Hale fell back on a famous constitutional shield. He pled the Fifth Amendment, arguing that answering the grand jury's questions and handing over those documents might actually tend to incriminate him.
But the Supreme Court struck this down as well, and this quote right from the justices perfectly explains why Hale's Fifth Amendment plea totally failed. You see, the Fifth Amendment only protects you if you are in actual danger of being prosecuted for your testimony. In this specific case, the government had already granted Hale statutory immunity under a 1903 provision related to the antitrust law. Because the actual threat of prosecution was removed, the protection of the Fifth Amendment just vanished.
Let's break down exactly how this works in practice. Step 1, a witness is compelled to testify or hand over evidence. Step 2, a statute guarantees absolute immunity from prosecution for anything they disclose. Step 3, because there's no longer any risk of criminal penalty, the constitutional right to refuse to answer is legally removed. Once the threat of present criminality is gone thanks to statutory protections, the law dictates that the witness absolutely must answer the questions, regardless of how much it might damage their reputation or cause them major practical difficulties later on. So then Hale tried another angle. He tried to argue that, hey, even if he had immunity, the corporation didn't, so he should be able to withhold the documents to protect the company. Well, the court wasn't having that either. They firmly established the personal privilege rule. The Fifth Amendment is purely personal. A corporate agent simply cannot use their own personal Fifth Amendment rights to shield a third party, and they definitely can't use it to shield the corporation from having to turn over its own documents.
Section 4. Individuals versus corporate entities. And this brings us right to the absolute core, the philosophical battleground of this entire explainer, the legal disparity between natural persons and corporate entities.
By juxtaposing these two entities side by side, we can see exactly why the Supreme Court ruled the way it did, and why corporations ultimately have fewer constitutional protections. An individual has inherent constitutional rights that exist long before the state was ever organized, right? An individual owes no duty to divulge their private business to the government. But a corporation? The court basically defined the corporation as a creature of the state. It's presumed to be incorporated for the benefit of the public, it receives special privileges, and therefore it is subject to a reserved right of the legislature to investigate whether it's actually abusing those state-granted privileges. Because of this legislative oversight, a corporation simply cannot refuse to show its hand.
Now, it isn't totally black and white. Despite being a creature of the state, the court noted a really crucial nuance here. And this brilliantly illustrates the complexity of corporate law. A corporation is, at the end of the day, still an association of individuals. And because of that, it doesn't waive all constitutional immunities. For instance, a corporation's property cannot be taken without due process or just compensation. They aren't entirely stripped of all their rights.
Hale's company was chartered in New Jersey, and they tried to argue that the federal government had no jurisdiction over a state-created entity. But the court invoked the concept of dual sovereignty. Because the corporation was engaged in interstate commerce, it was operating under the authority of Congress. The federal government holds the sovereign authority to vindicate its own laws, meaning jurisdictional limitations don't allow powerful monopolies to just hide behind state charters the second their business crosses state lines.
Section 5. Fourth Amendment subpoena limits. Okay, so if a corporation is subject to federal oversight and it absolutely cannot plead the Fifth Amendment to withhold its documents, does that mean the government can just swoop in and seize every single piece of paper a company has ever produced?
Well, in a major twist, the Supreme Court actually sided with Hale on this final point. They ruled that while corporations do not have Fifth Amendment protections against self-incrimination, they are entitled to Fourth Amendment protection against unreasonable searches and seizures. The court looked at that massive, sweeping list of demands we talked about earlier and declared it was just far too broad. Demanding effectively every single document a company has ever produced was deemed as indefensible as an illegal search warrant.
Now, what is really fascinating is that the justices themselves fiercely debated this outcome, offering some incredibly varied nuances regarding how the Constitution even applies to corporations. Justice Harlan concurred with the result but argued that corporations are invisible artificial beings, not people, and shouldn't get Fourth Amendment rights at all. Justice McKenna thought the massive subpoena was perfectly fine, arguing every single letter might be necessary to prove a monopoly existed. And on the completely opposite end, Justice Brewer dissented entirely, arguing that corporations are just associations of citizens and should have the exact same Fourth and Fifth Amendment protections as any individual. It really proves that the constitutional rights of a corporation were a highly contested, bleeding-edge frontier back in 1906.
Section 6. Modern Corporate Investigative Oversight. Let's conclude our roadmap by looking at how this landmark ruling shaped the world of business and law we live in right now. Hale v. Henkel established the absolute bedrock for government authority to inspect corporate contracts and records. Because the court decided that corporations cannot plead the Fifth Amendment, the government gained the essential power to subpoena internal contracts, ledgers, and communications. Pretty much every modern investigation into corporate governance, white-collar fraud, or monopoly powers relies on this exact precedent, that a corporation cannot completely shield its documents from the state that birthed it.
But as we navigate modern data privacy, digital communications, and massive global corporate governance today, this century-old tension remains incredibly relevant for all of us. If a corporation is ultimately just an association of individuals, we have to ask, where exactly does individual human privacy end, and where does the state's right to oversight actually begin? It's a complex, tricky balance of power that started with a guy named Edwin Hale over 100 years ago, and it's a debate we're very much still having today. Thanks for joining me for this explainer, and keep questioning the structures around you.